Okay, so today we're doing a deep dive into a pretty complex situation. We've got a stack of legal documents here.
Yeah, and well, it reads less like a standard court case and maybe more like a financial nightmare for the person involved.
Exactly. We're unpacking Okoroama versus Kleban et al. It's all tangled up in the world of litigation funding.
And our goal here is really to understand this conflict. There's an $800,000 personal injury settlement at the heart of it.
But here's the kicker, and this is really for you, the listener, to think about. After all the payouts, especially to these high-interest funders, the plaintiff, Cecilia Okoroama, she was offered just a tiny slice of that $800 K.
A really small fraction. So the question becomes, how did that happen? How did this alleged overreach occur?
And it's not just about, typical fees. We're talking about allegations of incredibly aggressive funding terms, maybe even misconduct, and importantly, some sworn statements affidavits that seem to clash directly with the documented facts.
Right. We need to look closely at the players in the money flow. The plaintiff, her attorneys, specifically Alla Kleban and Eric Subin, the paralegal, Lana Aronoff, who also went by Svetlana, and then the funding companies themselves, Chroma, Dynamic, U.S. Claims. We're basically tracing how the advice given, the agreements signed, and the money distributed all connect.
Let's start with the plaintiff's side, Cecilia Okoroama's story, as she tells it in her affidavit. She paints this picture of being really vulnerable, injured, in pain, couldn't work.
Desperate, basically. Needing money for just living expenses, medical bills.
And right there, early on, there's this piece of advice she claims she got from the Kleban defendants, her lawyers.
Yeah, this is crucial. She says they advised her to stop using her Medicaid insurance.
Stop using Medicaid. Why?
And switch to doctors they recommended. Doctors who wouldn't bill insurance, but would instead get paid through something called a doctor's limit.
So a promise to pay them out of any future settlement money.
Exactly. Which means those medical costs, which Medicaid might have covered or capped, are now her personal debt. And that debt gets rolled into these funding deals.
Okay, so that advice directly sets up this later financial burden, and she alleges the process of getting these funds wasn't exactly straightforward either.
No, she talks about quite a bit of pressure, mainly from the paralegal, Lana Aronoff.
Svetlana, yeah.
Bringing loan papers to her house, sometimes late at night, she says, rushing her to sign.
Without really explaining the terms, which she calls, quote, horrendous, predatory terms.
That detail, someone vulnerable, being pressured late at night with complex financial documents, it's a powerful part of our claim.
So what did the numbers actually look like? What did she borrow?
Okay, so the documents show between July 2016 and November 2018, across 10 transactions, she borrowed a principal amount totaling around $93,785. Let's call it $94,000 principal. Now, fast forward to March 2019. The $800,000 settlement comes through. What did the funding companies claim they were owed then? This is where it gets pretty staggering. The payoff amount demanded had spiked to an incredible $607,000.
Wait, $607,000 from $94,000 borrowed just, what, months or a couple of years before?
That's what the documents state, in roughly 18 months to 2.5 years, depending on the specific loan tranche.
The interest rate must have been astronomical.
Well, she calculates it in her filing. She estimates the debt was compounding at an annualized rate of 52%, effectively growing to over 600% of the principal by settlement time.
Wow. And so out of the $800,000 settlement, after paying that $607,000 back, what was she left with?
The initial offer presented to her by her attorneys was just $98,000.
$98,000, barely more than the principal she borrowed in the first place. Less than 15% of the total settlement.
It was apparently increased slightly later, but yeah, that initial offer tells you a lot about where the money went.
So how do these agreements even work? You mentioned they're often structured not as loans, but as something else.
Right. To arguably get around state usury laws, which cap interest rates on loans, they structure them as sales or assignments of future settlement proceeds.
Okay, let's look at one. We have a Chroma agreement here, dated December 19th, 2016. What does it say?
The terminology is key. Okoroama is the seller. Chroma is the purchaser. It's called an assignment sales, springing assignment, monetable lien agreement. Very complex name.
So Chroma is purchasing something. What exactly are they buying in this specific deal? The purchase price listed is $110,653.32.
Right, but that's not cash in her pocket. The first page breaks down where that $110 actually went, and this is really revealing.
Okay, let's see the breakdown.
A, direct payment to Cecilia Okoroama, only $10,000.
$10,000 out of $110,000. Okay.
B, case cash funding buyout. $31,653.32. That's paying off a previous, likely similar funding lien agreement.
So rolling old debt into new, higher cost debt?
Seems like it. Then C, D, and E, doctor fees. A total of $64,000 paid directly to Doctors Obedience, Sonstein, and Boldenhofer.
64,000. There are those doctors she was advised to see instead of using Medicaid. Their lines are being paid off by folding the cost into this funding agreement.
Precisely. So those medical bills aren't just lines anymore. They're now part of a principal sum that's compounding at that incredibly high rate we discussed.
Making the healthcare itself exponentially more expensive for her in the long run.
Exactly. The agreement itself shows how quickly that $110K purchase escalates. After 18 months, the payoff amount was scheduled to be over $215,000. After 3 years, nearly $300,000. It's designed to grow fast.
And there's one more item on that list. Item F, what's that?
Item F, a $5,000 medical management fee payable to a company called Statesman Services, Inc.
Statesman Services, who are they? And why is the plaintiff paying a medical management fee through a litigation funder?
That's the million-dollar question, isn't it? And this fee isn't a one-off. We see it in other Chroma agreements, too. Another $5,000 here, $500 there. It adds up.
Okay, so who is Statesman Services, Inc.? This seems odd.
Well, this is where the potential conflict of interest really comes into focus. Public records, specifically a UCC financing statement for Statesman Services, list its mailing address as 655 Dolphin Drive, Hanfell Neck, New York.
And why is that address significant?
Because that public record and other information connecting the dots links Statesman Services, Inc. directly to Lana Aronoff, the paralegal.
The same paralegal who was allegedly pressuring the plaintiff to sign these documents?
The very same. And specifically, it appears connected to her husband, David Aronoff. Some fee schedules even reference payments related to David A.
Wait, so are you saying fees from the plaintiff's high-interest funding agreements were being paid out to a company connected to the law firm's paralegal and her husband?
That's what the documentation strongly suggests. A company owned by the paralegal's family appears to be receiving management fees that are baked into these funding deals.
That feels like a massive conflict of interest. If the paralegal or her family is getting paid by the funder, whose interests are they really looking out for when dealing with the client?
Exactly. It raises serious questions about fiduciary duty. Now let's look at what the attorney said about this under oath.
Okay. We have an affidavit from Alla Kleban, the main attorney, dated December 5, 2019. What did she say about compensation from these funders?
She made a very clear, very specific statement. Quote, "Neither I, my firm, my spouse, nor my employee, Lana Aronoff, have received any fee or other compensation from any of the 4 funding companies from which plaintiffs sought and obtained litigation funding."
Hold on. She swore under oath that her employee, Lana Aronoff, received no fee or compensation from the funders.
That's what the affidavit says, unequivocally.
But we just saw funding agreements showing fees being paid to Statesman Services, Inc., a company linked directly to Lana Aronoff's husband, David. How can both things be true?
Well, that's the core of the contradiction, isn't it? You have financial documents showing money flowing to the paralegal's family company from the funding agreements, and you have the attorney swearing that no such compensation occurred for her employee.
It looks like a direct clash between the sworn testimony and the documentary evidence. I mean, that raises the question, is that perjury?
But that's certainly the implication the plaintiff is making. When sworn testimony seems to directly contradict financial records filed in the same case, it's a serious issue. You have to ask if the court or even the district attorney should be looking at this discrepancy.
It's a stark contrast, and Alla Kleban wasn't the only attorney whose statements seemed challenged by the documents, right? What about Eric Subin, the trial counsel?
Right. Subin also filed an affidavit. He tried to distance himself, claiming he had no personal discussion with the plaintiff about the funding and was not involved in the negotiation of any funding agreement.
Okay, so he's saying he wasn't involved in setting up these deals?
Yes.
Yeah.
But there's Exhibit B attached to some of the funding agreements. These are attorney acknowledgement pages.
What do they say?
They contain language, apparently sworn to by the attorney signing, affirming that the attorney reviewed the agreement and explained its terms to me, the seller, meaning the plaintiff.
So the documents seem to show an attorney certification that the terms were explained to the client.
While Subin's later affidavit denies having those discussions or negotiating the deals at all.
Another major contradiction. Whether he signed them or disputes signing them, the presence of these acknowledgments directly undermines his claim of non-involvement in his affidavit.
It really highlights the alleged breakdown in clear communication and fiduciary responsibility. Did the attorney explain these complex, high-cost terms or not? The documents and the testimony appear to be saying different things.
When you put it all together, the vulnerability, the advice about Medicaid, the alleged pressure, the insane interest rates disguised as a sale,
The fees flowing to the paralegal's family company.
and then the sworn denials from the attorneys about compensation and involvement that seem to contradict the actual paperwork.
It paints a really troubling picture. It's not just a dispute over money. It's about trust, ethics, and the systems meant to protect clients.
So we've really journeyed through these dense documents today, haven't we? From Cecilia Okoroama's initial situation, relying on her lawyers.
Right, through the mechanics of these funding agreements, turning medical lesions into rapidly compounding debt labeled as a sale.
We saw how that $94,000 principal exploded to a $607,000 liability, wiping out most of her settlement.
And we followed the money trail, specifically those fees to statesman services, connecting back to the paralegal's family.
Which then led us straight into the contradictions in the sworn affidavits from the attorneys, denying that compensation pathway and minimizing their involvement.
There's a lot to take in.
Definitely. And for you listening, the big takeaway here really has to be about the critical importance of clear lines. The line between your lawyer's advice, their duty to you, and any outside financial interests.
Especially complex, high-cost financial products like litigation funding. This case, as laid out in these documents, is kind of a cautionary tale about what can happen when those lines get blurred, or maybe even deliberately erased.
The information asymmetry is huge. The client is vulnerable, trusting, while the agreements are dense, potentially predatory, and then key figures deny involvement under oath.
It really makes you think. Given how much litigation funding happens every single day, you have to wonder, are the current rules and ethical guidelines enough?
Especially when the agreements themselves are structured to shift risk and potentially obscure liability, and the people involved can later claim they weren't compensated or didn't explain the terms, despite documents suggesting otherwise. It leaves vulnerable clients in a very precarious position, doesn't it?
It certainly poses a significant challenge to the system designed to protect them. A final thought to really chew on.